Well, as I mentioned at the start of the show, we have a guest joining us, Sidney Powell. She's joined us before. Here we are in the coronavirus shutdown, so she is joining us on camera. And I will tell you one reason I wanted to invite her on is that she has a new book out, The Conviction Machine. The book is entitled Conviction Machine, Standing Up to Federal Prosecutorial Abuse. It is actually co-authored by Sidney Powell and Harvey Silverglate. And I wanted to ask Matt the Wonderful to put a picture up of the book. This is the cover up. You can order it on Amazon. In fact, on our website, if you go to our website, AmericanWeTalk.org, under shows, list of links, this is there, the link to order on Amazon. I've ordered on Amazon. It's going to arrive tomorrow. So I also have it on my iPad so I can talk with her about it intelligently. But one reason among many I wanted to have her come on is to talk about her new book. So I believe we have Sidney Powell. Hello.
Hey, Debbie. Thank you so much.
I'm so glad you could come on and join us. I know you're very busy, and my gosh, you have come up with another amazing book, eye-opening book. First book I should mention that we've talked with Sidney about on the show before, I've mentioned many times, License to Lie, also a stellar book. But this one we're going to focus on today is called Conviction Machine, and I'll get to it in one moment. But I do want to start by asking, you represent Lieutenant General Michael Flynn. And I realized getting ready today, I don't even know the status of his case. Like, where do we stand with that?
Yes, we're in Wonderland, as best I can tell. We have pending motions to dismiss for egregious government misconduct, and also motions to withdraw his guilty plea based on everything from government misconduct, their breach of the plea agreement, when they tried to get him to lie last summer in a case against his former business partner in the Eastern District of Virginia, to the fact that his former law firm, Covington and Burling LLP, led by former Attorney General Eric Holder, is and was in an egregious conflict of interest when they continued to represent him after they had done the Foreign Agent Registration Act filing on his behalf that came quickly into the crosshairs of Special Counsel Robert Mueller and prosecutors Andrew Weissman and Brandon Van Grack and company. And also their multiple acts of ineffective assistance of counsel, including not telling him all the information the government disclosed. It wasn't very much, but it was very important at the last minute before his guilty plea, and allowing him to be coerced under threats of indicting his son immediately if he didn't plead right then, and not disclosing that material term to the court.
So these motions, I couldn't even write fast enough, but the one I wrote down, motion to withdraw his guilty plea, that is pending before the district court judge. I mean, he's got the motion, the judge has pending for a motion to withdraw. And then, so that would then, if that were to be granted, what is the legal impact of that? Tell us what happens then.
Well, we would be back to square one, and the government would have to decide whether to try to prosecute a case it completely made up and that exists only because of government misconduct from its very inception. In fact, one of the things I discovered only by virtue of the Inspector General's report this last December was that the FBI slipped an agent into what was supposed to have been purely a presidential briefing of then candidate Trump on August 17, 2016, long before the election. They did that specifically because General Flynn was one of three people that was going to be there. They wanted to spy on General Flynn, quote, assess him, end quote, gauge his mannerisms, get a baseline read on him, and collect whatever information they could collect in case they needed to interview him later as a subject, i.e. meaning if he winds up in the White House with President Trump, which is exactly what happened. And then they did that interview just 3 or 4 days after the inauguration on January 24th. But the timeline is astonishing. It's August 15. Of course, they opened Crossfire Hurricane the very end of July 2016. They immediately opened cases on Papadopoulos, Page, and Manafort because they, quote, have, connections with Russia. They don't open on Flynn then. On August 15, they have a discussion in McCabe's office about the insurance policy, and Strzok and Page text about it that very day, August 15, 2016. The next day, August 16, 2016, they open the case on Flynn. August 17, the day after that, they send the agent into the presidential briefing.
You know,
they hid that information from us about the agent being in the presidential briefing, despite it was for the express purpose of laying the groundwork for the later ambush interview that McCabe set up on January 24th. The prosecutor hid that from us all along. It's only because of the Inspector General's report in December that we received that information.
It is simply breathtaking. I mean, honestly, even in the midst of this coronavirus kind of not just pandemic, but pandemic of fear, all of this is still lurking in the background and is you cannot overstate its importance in our country. And what happened to a noble public servant like Lieutenant General Michael Flynn, how the FBI was willing to, and Department of Justice willing to contort whatever it could. It's truly breathtaking. One other thing you mentioned.
It's even worse, Debbie, because right now the government is working with his former counsel at Covington and Burling to try to defeat the ineffective assistance of counsel claims, and that's why we're on hold. The next status report from the government is due on April 24th to decide if they can even set a briefing schedule yet for when to reply to our conflict of interest and ineffective assistance of counsel allegations, because Covington is now providing them whatever information Covington wants to give them from our client communications.
It's truly breathtaking. On the motion, you're asking the court to rule there was ineffective assistance of counsel. What's the outcome of that for if the court were to agree that Lieutenant General Flynn had ineffective assistance of counsel? Does that again trigger a possibility of the government having to start over in this case, or does that just bring about a dismissal?
That would bring about withdrawal of his guilty plea. The withdrawal motions were based on the government's breach of the plea agreement and then the conflict of interest and ineffective assistance of counsel. They're still pending the motion to dismiss for egregious government misconduct that covers everything from their makeup of the entire case through the Inspector General's report.
Wow. Okay. Do you have any idea if Attorney General Barr, I know he obviously knows about the case, is he attuned, as far as you know, into understanding how egregious the conduct was by the government against Lieutenant General Michael Flynn?
Well, we know that he named a special prosecutor, sort of the U.S. attorney for the District of Missouri, to work with Mr. Van Grack on this case. Ironically, Mr. Van Grack has had to be taken off the pleadings on the conflict of interest and ineffective assistance of counsel issues because he's actually a witness to all that, but he's still participating in the background, I'm sure.
Okay, I keep thinking there needs to be, I guess whatever happens, I want Lieutenant General Michael Flynn to be free, but it just seems like the best outcome for America would be a very broad-based rebuke of all that the Department of Justice did, all the way they conducted this, just a dismissal of all charges and a big fat public apology is about what seems to be due.
Exactly, and the public is not going to have any confidence in the Department of Justice or the FBI or the court system until this case is dismissed and all the misconduct is acknowledged. And the longer the Department of Justice and FBI take to do this, the worse it looks. We still have not been able to get the original FBI 302 report of the interview conducted of him on January 24th. The prosecutor says he doesn't have it. Well, that means it's not in his back pocket. But things like that don't go missing. It's in the FBI Sentinel system, and they've never produced it. And Judge Sullivan, astonishingly, did not order them to do it, nor do we have the January 30, 2017 memo inside the Department of Justice completely exonerating Flynn of anything Russia-related.
That is among the most amazing pieces. Okay, we can get sidetracked and talk about I could get sidetracked and talk about the Flynn case for a long time, but I do want to actually turn to your book, and we're kind of touching on some of those issues anyway. Again, the book is called Conviction Machine, Standing Up to Federal Prosecutorial Abuse by you, Sidney Powell, and Harvey Silverglate. So I have to tell you that this is a topic I think we talked about a long time ago on the show when we were talking about Lieutenant General Michael Flynn. In America, people pretty much have a sense that, we have maybe not a perfect justice system, but one of the best on earth, that we have high, noble, standards set. We have rule of law applies to everyone. We have, the blindfolded Lady Liberty. But there is a growing sense in the country, recognition that the prosecutors hold tremendous power and really unaccountable power, like we were just talking a moment ago. where is there a vehicle for the wrongs they have done to be righted? What has happened to Lieutenant General Michael Flynn and others in the course of the Mueller investigation who were just harassed and mistreated by the prosecutors? It seemed like there's just no vehicle available to the people. So I actually was going to dive into several discussions in several of your chapters, but overarchingly describe the problem you're talking about when you say federal prosecutorial abuse. What are the big pieces that you're describing that are occurring today in the federal prosecutorial abuse?
I would characterize it as over-criminalization, for one thing, making up crimes. We already have too many federal laws that make things criminal that people don't even know are criminal. That's why Harvey Silverglate, my co-author, wrote 3 felonies a day several years ago to bring people up to speed on the fact that they can go about their daily business and commit 3 felonies every day without knowing it because there's so many blooming criminal laws. And then overzealous prosecutors will even stretch those beyond the way they were intended. That happens all the time. That's why Arthur Anderson and 85,000 jobs were destroyed, only to be reversed by the unanimous Supreme Court 2.5 years later. That's why 4 Merrill Lynch executives went to prison on an indictment that criminalized innocent business conduct. These people can make an honest business transaction seem like a federal offense just by the way they word the indictment.
Yep.
And they also hide evidence all the time. It's called the Brady Rule. They have an obligation to disclose to the defense all the evidence they have that either contradicts their case or impeaches their witnesses or mitigates the defendant's punishment in some way. That's the rule of the Supreme Court in Brady versus Maryland, but they violate it all the time, as they did in the Merrill Lynch case I talk about in License to Lie. And we talk about that in Conviction Machine a lot. The Brady Rule needs to be made into a statutory law with penalties for its violation because it's not followed at all. And judges are not enforcing it, as we can see by Judge Sullivan's decision back in December, not requiring the government to produce a single document, even admittedly the full documents of things they had only given us summaries of that were in fact exculpatory. And you cannot rely on a summary. A summary is not evidence, and they're never accurate. I've never seen an accurate summary of a document by a prosecutor.
On the Brady Rule, let's start with that because we've talked about that many times in other cases and contexts in this particular case. But and the Brady Rule, which basically says if you're the prosecutor, you simply must turn over to the defense attorney, as you were just saying a moment ago, evidence that's exculpatory. What is supposed to be, and other categories, but what is supposed to be the enforcement mechanism of the Brady Rule? If a prosecutor fails to turn over and the defense attorney can prove that, isn't the outcome that the prosecution is dismissed by a judge, either the trial judge or an appellate judge?
It could be, but that's extremely rare. Usually the best that happens is a new trial. And prosecutors aren't sanctioned for it at all. Judge Sullivan did hold some in contempt in the Ted Stevens case that I also discuss at length in License to Lie, exposing corruption in the Department of Justice and to some extent in Conviction Machine. But that doesn't happen very often, and he sure didn't follow that in the Flynn case. So it's up to the whim of individual judges. There's no real standard practice for it except to accept the government's bald assertion that, oh, we know what our Brady obligation is and we follow it.
And so you mentioned the possible way to remedy this with the Brady Rule would make the Brady Rule legislative, to have Congress pass a law, define the standard, and then define penalties for failure to comply. Is that, I don't want to mistake, is that what you're saying?
Yes, that's one thing that needs to be done for sure. Judges could fix it right now by entering a very clear Brady order in each of their courtrooms and actually enforcing it. But they don't do it. And that's inexplicable to me.
Well, that's an interesting thing. You obviously are an experienced federal prosecutor. I forgot, I should have looked it up, but you have filed many appeals. You write federal appeals in the criminal context. But I remember just in the brief summary, here's my law school experience. Between first and second year of law school, I interned at the U.S. Attorney's. I went to law school in Washington. I interned at the U.S. Attorney's office. And I came to realize that the judges who are trying to be, I mean, they understand their job, but they see the same prosecutors day after day. And so they develop a friendship, or at least a very much a professional respect. And they don't want to really, I mean, there's an assumption in the system that if you've gotten all the way to being prosecuted in federal court, you probably did something wrong. And so there's a tentativeness about judges deciding to really go hard in criticizing a prosecutor because you work with them every day and they're in your courtroom every day. Do you think that's valid? Do you think that's a problem?
Yes, that is a problem, and it happens all the time across the country. It's okay if you really know the prosecutor and you know their level of personal integrity, but it just doesn't work that way anymore like it used to. In fact, when I was a prosecutor, we would confess error, meaning we would agree with a court that the prosecutor had in the trial had done something wrong and request a new trial for a defendant. Or we would tell the federal judge he couldn't do something if he was too pro-government, as many of them are. I haven't seen a prosecutor do that in any case that I can think of in the last 20 years. So it's become a game to win a conviction at any cost instead of seeking justice. And the Flynn case proves that in spades.
Yeah. So what about the description you have of overzealous prosecution? Again, I will say, I think that the kind of in the abstract or generic thought about prosecutors is prosecutors are all about enforcing existing law, and defense attorneys are all about getting people off no matter what really happened. I mean, that's a very overgeneralization, but the assumption is that prosecutors really just have a mission of fulfilling their job of enforcing law or of understanding what laws exist, and based on facts that are presented to them, they prosecute. They prosecute to see, are you the bank robber? And they're easy kinds of cases. You either did rob the bank or you didn't. But when you get into complex kinds of prosecutions, the kinds involved in Enron, you really need a prosecutor to have the highest sense of integrity to look at the statute, understand what it means, and then apply it to this case. So how do we get here that we have overzealous prosecutors kind of more determined to contort legal, as you said, legal things people do, contort those into crimes? How do we get here?
Well, they decided to politicize and weaponize what is supposed to be the rule of law that applies equally to everybody, regardless of station, position, political party, or anything else. And instead, they've gone about targeting individuals instead of prosecuting crimes. That's what the Enron situation was all about. Bush had directed them to ferret out the white-collar crooks. Well, what they did was they made sweetheart plea deals with the few people that had actually stolen money from Enron. There were actually only 2 of those. And then they went berserk prosecuting anybody that had anything to do with them, trying to, quote, send a message to Wall Street, end quote, that it was a crime to have done business with Enron, and destroyed Arthur Andersen and 85,000 jobs by piecing together parts of 2 different statutes to make a crime out of something that wasn't. That's just not, prosecutors don't get to make laws, but that's exactly what they tried to do. And then the Obama administration went even more berserk doing the same thing. They realized that they could change the law better by creative prosecutions than they could by getting anything through Congress. So they went rogue and prosecuted all kinds of people for things that weren't crimes.
So what is the answer, Sidney? I mean, you just have such a high standard of integrity, which everyone is why so many people admire you and your writing and your advocacy. But what is the answer to getting or resolving the problem of overzealous prosecutors? I mean, you can say more training, annual training for prosecutors to remind them, by the way, you're only supposed to be here to do such and such. But if as an example right now, what we're looking at with Lieutenant General Michael Flynn, you're looking at what seems to have developed among some in the DOJ, a culture that justified overzealous prosecution, justified going after people. And how do you fix that? How do you fix that culture that is validating and encouraging this conduct?
Well, a lot of people need to be fired. I think there needs to be a review inside the Department of Justice for intentional Brady violations. The Office of Professional Responsibility needs to be completely revamped. When I talk about prosecutorial misconduct, I'm not talking about accidental overlooking something, deep in a file that should have been produced to a defendant and wasn't. I'm talking about the deliberate crafting of charges and deliberately hiding evidence from the defense that they know undermines their case. It happens in far too many cases. Even one is too many, but it happens a lot. In fact, friends of mine who are regularly defense attorneys, I'm not, I only do it on occasion, tell me that it happens regularly. That's completely unacceptable. The tone has got to be changed from the top down. People need to be fired. They need to be put in different positions to learn different things. There's a lot that can be done, and Congress needs to abolish the absolute immunity that prosecutors enjoy and make them civilly liable, just like police officers are, under nothing more than qualified immunity, particularly for their intentional and deliberate misconduct.
Can you describe what that is for our listeners? I'm so happy to be talking with you. I love that this discussion. Can you describe for our listeners what you mean about prosecutors? Because I think having qualified or absolute immunity, because I think that people think, well, the prosecutors wouldn't dare do the kind of things you're describing because they get in trouble with someone. They would get sued. They would get prosecuted. So would you describe with the current situation and what it should be?
Right now, I don't know of any prosecutor who's ever been prosecuted from as a result of his work in any case, even if he made up a crime and sent an innocent person to prison. The bar associations won't do a blooming thing about it, as we explain in License to Lie, because Bill Hodes, one of the leading legal ethics experts in the country, and I filed grievances against 3 of the prosecutors. I've never filed a grievance against anyone in my entire multi-decade career, but we did against those prosecutors, and they mysteriously evaporated or were kicked to the curb without any serious, meaningful review at all, even though they were massive filings and documented. They're available on my website under Sources for License to Lie at licensetolie.com. Which reminds me, the Flynn pleadings are available at sidneypowell.com on a whole Flynn page.
I was going to ask you, go ahead, please.
Associations do nothing. The courts don't want to do anything. The Ninth Circuit has been the most aggressive in holding the government accountable, but they haven't gone far enough. And the other circuits, and the DOJ in particular, have circled the wagons to protect prosecutors instead of holding them accountable.
You can see the dynamics working if you're in a prosecutor's office and you are, it's a culture of a little bit of political vengeance or political bent to it, and everyone seems to be on that same team, and you see things that aren't right, but you're not worried anything will happen to you if you speak up. You can understand why we've gotten where we are. We have people who think, why would I speak up? I'm the only one who might be commenting this way. And no one's going to back me up. I mean, I can see how it gets. I love everything you're saying, but I can see how it could get this way. And yet I step back and think, I think most Americans think what you're saying is absolutely shocking.
It is shocking. And I've come to the realization that there should not be career prosecutors. I think a maximum of 15 years is long enough for anybody to be on the public payroll. It just simply breeds entrenchment and complacency and everything that's wrong with the system.
Okay, so I mentioned I have all your chapters in the book. I can't go through all of them, but I did want to say, first of all, you write so well. License to Lie. I remember reading that thinking, if this was if it was a fiction work, I would be turning pages like this, but it was true. And the same thing's true of this book. As I said, I have an iPad I can't hold up for you, but I want to encourage our listeners to get it and to really, this is part of being a citizen activist, a citizen patriot, is you have to, when you read these kind of things and you see the way the justice system is getting off track and innocent people are prosecuted for things that aren't really crimes, this is the beginning of the demise of this glorious creation of America, what the Constitution created, this rule of law and applicable to everyone, and justice being blind. These are truly country-changing things you're talking about. One of the quick things you mentioned, over-criminalization. Is there some place where, as anyone started the project of trying to describe, maybe this is your co-author, trying to describe how we have over-criminalized? I mean, what you're talking about, and what we need to do, what has to be repealed at the federal level. Is that an ongoing project?
I don't know that anybody in Congress is really working on it. but it needs to be worked on, and there's some fairly simple fixes for a large part of it. For one thing, they could simply enact a statute that says nothing can be criminalized unless Congress has enacted a specific statute that makes it a crime. Because right now, aggressive prosecutors are taking civil regulations from the Code of Federal Regulations and putting them in conspiracy statutes and making them 5-year federal felonies and things like that, aside from piecing together parts of different statutes to make a crime out of something that isn't, or drafting an indictment in such a way as to make innocent business conduct sound like a crime. A lot of times the prosecutors don't even understand the business transaction.
Yeah, and actually it's interesting too, I think, for the average Joe American, the kinds of prosecutions that occur are very complex cases and complex definitions in federal law, what is impermissible. And I can understand why many people feel like they don't really even feel justified criticizing or questioning, but people who, like you, long-term, been a prosecutor, been outspoken. It's really a public service for you to have written this book and to be advocating really for the average Joe who can get overrun by our legal system without even, and most people assuming it's not possible in America, and you're saying not only it's possible, it's happening. So a stellar book. I want to add one more thing with you, Sidney Powell, which is, I don't know if I'll be the first one to say this, but I really hope that if Attorney General Barr, for whatever reason, no longer is Attorney General, and we're looking for somebody new, honest to goodness, I wish you could be nominated for Attorney General. And not just because you're a good writer, but the principles, the ethics, the determination to insist upon the return to the values our justice system is based on. I mean, I don't know many people as committed as you are, and as outspoken and fearless and relentless. So, you know what? I'm wondering if I should just write a letter to the president and urge him to nominate you. I'm serious. You'd be a great Attorney General. That's not a question, but I'm just telling you.
I'm honored that you would suggest that. I can only imagine the number of people in Washington, D.C. that would need laundry service if that happened.
Okay, that's a funny thing. I have to tell you, I think, in fact, we were talking long before Attorney General Barr was even nominated or even confirmed, and there was a lot of sense that, I mean, we had to get someone new in there. You know, most people concur. Jeff Sessions it wasn't the right spot for him in Washington, and so we got Attorney General Barr in. But and I'm still really hoping. I'm gonna loop back now, if I can, to John Durham. Do you have any sense, based on who you see or what you know about in Washington, do you expect indictments to come out of the Durham investigation, the Trump-Russia collusion?
There certainly should be indictments out of it. I don't know, Debbie. It has taken way too long. It has not been done the way I would have proceeded to do it, as best I can tell. But again, I'm totally on the outside. I have no idea what evidence he's looking at. I was partly encouraged by Attorney General Barr's remarks to Laura Ingraham, but then the way he kept saying, you know, if there's enough evidence of a crime, it will be prosecuted. I remain concerned. And I mean, we all know what happened. We all know the FBI signed admittedly false now FISA applications to the most egregious, intrusive court that exists in the country, a secret Star Chamber court that simply signed off on them. And I read those applications. There wasn't a shred of firsthand information of wrongdoing in a single one of them.
Yeah, I've had many people making the same comment, and I've had it myself, and I'm not nearly the experienced, prosecutor that you are, but I don't understand why it's taking quite this long. And I know everyone talks about, well, you got to go ahead and you got to dot every I and cross every T. But at some point, I think people begin to lose a little of faith in the justice system because, as you're saying, many Americans have been following the FISA court application, the absurd level of the reason that the FBI should have known the entire dossier was just simply unreliable creative writing, and certainly not a sufficient seriousness and legitimacy to be the basis to be seeking warrants to spy on Americans from the FISA court, and yet it's taking so long. I'm concerned too. I'm very, very concerned too.
Well, their declination of the prosecution of Andrew McCabe, which was referred criminally by the Inspector General, completely invalidates the pursuit of any prosecution of General Flynn. McCabe was under oath. He knew exactly why he was being investigated. He had had the benefit of counsel. I don't know whether counsel was with him for the interview or not, but he had certainly consulted counsel at length before the interviews, and his interviews were recorded. None of that existed for General Flynn, who was interviewed in a drive-by ambush, and we've got evidence now that the government had produced to his prior counsel, but they didn't use it, that the agents schemed and planned at the highest level of the FBI to interview him in such a way that he would not even know he was the subject of the interview. Not only did they not warn him of his rights, but he did not even know he was the subject of the interview. I understood. He thought it was a friendly interview, right? He thought it was with the Trump administration, and he's with the Trump administration. Right. With friends that had been in the White House. One of the agents had been in the White House a couple of days before on a training mission. McCabe said he just wanted to send a couple of agents over to close up the issue. It was supposedly, just no big deal, all done. White House counsel not involved, no need for any counsel, according to McCabe. And they don't record it. Their notes don't match the 302s. The 302s were altered and revised until McCabe signed off on them after Flynn left the White House. Everything in the Flynn case was done wrong. There isn't a single aspect of the case in which they applied the rules, protocols, or norms. And to continue with this prosecution now in its third year is an absolute outrage, not to mention an incredible waste of taxpayer dollars and resources. Sidney Powell, I am so glad on behalf of Lieutenant General Michael Flynn that you are representing him. Honestly, across America, when the news came out that you were going to take over his representation, so many people were cheering you on because they realized he had found a fighter, a lawyer who's a fighter. And I'm so gratefully representing him. Also, I'll mention again for our listeners, the new book out by Sidney Powell and co-author Harvey Silverglate, Conviction Machine, Standing Up to Federal Prosecutorial Abuse. Yeah, there's a picture of it. Really a great read. And I thank you for writing it. You're bringing your wealth of knowledge and your passion for the justice system. It's a gift to America. So Sidney Powell, it's great talking with you. Thank you for joining me. Thank you, Debbie. I really appreciate it. Okay, folks, I get that book, get it out there, and understand it so you can tell your friends. That, my friends, was an interview today with Sidney Powell. So glad we got to have her join us.